Good morning, welcome back. Today we will start with section 114. I am Jayashree from Institute of Sai. Section 114 speaks about review. When can review petition be filed? Okay, so review petition is filed in the court where the order or decree has been passed. It's not like appellate court or the high court or something like that. It is not like that. Where a decree or a particular order has been passed, review petition is submitted in the same court and it is tried by the same court which passed the decree or order. Okay, so now we'll go to what is a review. When can a review be filed? Okay, so review can be filed, number one, where appeal is allowed under the Code of Civil Procedure, where an appeal is allowed but it has not been exercised. Exercised means what? Appeal is allowed under law, but the aggrieved party has not utilized his right to file an appeal. So instead of filing an appeal, what he is doing? He is filing for review. Okay. Or number two, where no appeal shall be allowed. Where there is no appeal which is allowed under the Code of Civil Procedure, there also review petition can be filed. Okay. Third one, where a decision is on a reference by the Court of Small Causes. By a decision on a reference from a Court of Small Causes. So the Court of Small Causes, there has been an order. Okay. So based on the order, the Small Causes has given a reference saying that it can be filed for, a review petition can be filed. Okay, so decision of Small Causes, review petition can be filed. Number two, where there is an appeal which is allowed under the Code of Civil Procedure, but the person has not exercised his right to file an appeal. Number three, where no appeal is allowed under the Code of Civil Procedure. Okay, in that case also review petition can be filed. Next we go to section 115, which is revision. All of you are aware that revision petition is filed before the High Court, right? So in which circumstances can a revision petition be filed? Okay, number one, where, okay, here what is common is court. So you can just underline the High Court may call for record of any case. Okay, all those things are there. Then you can just underline if such subordinate court appears. See, you have to know what appears means. See, everything starts with prima facie. Am I right? When it comes to law, everything starts with prima facie. Anything which appears. Okay. So prima facie something appears. To be like this, to be like that, then that is known as appears. Okay. So be very careful. Don't say subordinate court has. See, when you are writing also, in the exam and all, they are not going to bother much about all these things. But you are writing your judicial services, so you better to be aware about all these things. That's all. Okay. Okay. If subordinate court appears, what? To have exercised a jurisdiction which it does not have. Number one, where it seems to have exercised a jurisdiction which it does not have. What do you mean by jurisdiction? The area which can be tried by a particular court, that is known as jurisdiction. Am I right? A particular topic, a particular nature of case, when we have to file a civil case, we'll not go all the way to magistrate court or sessions court and file it. Am I right? Because they don't have the jurisdiction. Similarly, when we file criminal case, do we go to civil court and file? No. That is because each court has its own jurisdiction. Clear? So, what I was saying, to have exercised a jurisdiction which it does not have, or it has a jurisdiction, it has not exercised a jurisdiction which it has. So these are two opposite things. The court does not have a jurisdiction, but it has exercised. Okay. Second one is what? It has a jurisdiction, but it has not exercised the jurisdiction. Clear? Even then, there is an irregularity. Am I right? So in that case, revision petition can be filed to High Court. C. To have acted in the exercise of jurisdiction illegally or with material irregularity. Very, very important. Illegally, underline illegally or materially irregularity. Material, underline that material, because we have read in Evidence Act, am I right? What is material evidence? Correct? So anything which is relevant to the case, anything which is important to the case, that is material evidence. Clear? Same way when we come to CPC and this particular the clause C, same thing has to be applied. Material irregularity means what? It is a irregularity which affects the case or the party substantially. Material irregularity. Okay. See, where there is a jurisdiction, the court did not know that it doesn't have the jurisdiction, but it has passed an order. And that order has followed all the procedures of the court. Whatever are the procedures in each case, everything has been followed, right? So it may be taken to be a correct decision, even though because it becomes immaterial irregularity. Clear? Why? Because it is only that there is a technical error. What's the technical error? Court doesn't have the jurisdiction. Simple. Nothing else is affected. But whereas material irregularity means there is something substantial which affects the case or which affects the party to the case. Denial of justice, or probably principles of natural justice have not been followed. There are so many things like this, right? So, or something like this has happened. That is why we say to have acted in the excess of its jurisdiction illegally. Illegally means what? Unlawfully, right? It is against law. It is not like, okay, there is no law at all and I am doing it, so I am doing it. It's not like that. There is a law which says this is how it has to be done, but we are going against that law. That's known as illegality. So, exercise of its jurisdiction illegally or with material irregularity. Okay. Then the High Court may pass such order in the case as it thinks fit. We know that. Clear? Yeah. Then subsection number 2. The High Court shall not under this section vary or reverse. Please underline, okay, because this is very, very important. The High Court shall not, underline the word not. Okay, once you underline the word not, when you are studying, automatically you know what should be avoided by the court. Okay, the High Court shall not under this section. Why is it written under this section? Because there are various other sections which allows the High Court to vary the order. Vary means what? Different, right? Make the order, pass a different order or reverse the order which has been passed by the subordinate court. Actually, it is allowed under law. Am I right? But here in this particular section, in the section pertaining to revision, High Court has no power to vary. Vary means what? Pass a different order or reverse any decree or order against which an appeal lies either to the High Court or to the court subordinate thereto, where the person has the right to appeal. Clear? In such cases, the High Court cannot vary the order or it cannot reverse the order of the subordinate court. Clear? Instead, what can the person do? The person can go on appeal and say, see, the court did not have jurisdiction at all. There is a material irregularity. Whatever is the problem there, the aggrieved party can put forth its arguments. Okay, then subsection number 3, a revision shall not operate as a stay of suit, very important, or other proceeding before the court except where such suit or other proceeding is stayed by the High Court. So, stay order is something which is particular in nature. Am I right? Just because I file an appeal, just because I file a revision petition before the High Court, it doesn't mean that the case which is pending before the subordinate court. Pending means what? It is still going on, right? Okay. So, it is pending before the subordinate court. It shall operate as a stay of suit. No, it cannot operate as stay. Clear? Then next we go to section 116, which comes under part 9. What does part 9 say? special provisions relating to high courts not being the court of a judicial commissioner. Okay. Section 116. Part to apply only to certain high courts. This part applies only to high courts not being the court of judicial commissioner. Of course, now we don't have the post of judicial commissioner at all. But this was done somewhere in 1908, right? So there have been amendments which are going on. So just keep it in mind. That's it. Then now section 117, application of code to high courts. Save as provided in this part or in part 10 or in rules, the provisions of this code shall apply to such high courts. Such high courts means what? Nowadays the entire India is filled with high courts. Am I right? There is nothing called judicial commissioner. So this code applies to all the high courts except where the CPC specifically says this code does not apply to such places. Something like Nagpur, not Nagpur, Nagaland, okay, and tribal areas basically. So it doesn't apply. We cannot anymore say Jammu Kashmir. Please keep it in mind. Because we are so used to saying that all these years, now we cannot say that. Section 118. Execution of decree before ascertainment of costs. Where any such high court considers it necessary that a decree passed in the exercise of original jurisdiction shall be executed before the amount of costs incurred in the suit can be ascertained by taxation, the court may order that the decree shall be executed forthwith, except to so much thereof as relates to the costs. So execution of decree, how will it be done? That's the question here in this section, okay? So how will the execution be done? Wherever the execution of an asset is required, okay? So how will the amount be determined? We already saw how it will be expended, am I right? How the expenses will be met regarding after the execution, right? So here what we are going to talk about, how will the execution, the amount which is got from the execution, how will it be ascertained? How will we make sure what is the amount which is got? So while counting the money, okay, or while calculating the amount rather, while calculating the amount, how should it be taken? All the costs should be subtracted, okay? All the costs should be subtracted and the remaining part would automatically be the execution amount, okay? Section 119, unauthorized persons not to address court. We know this, right? Nothing in this code shall be deemed to authorize any person on behalf of another to address the court. What do you mean by address the court? Address the court means represent somebody. See, we as lawyers, unless we have wakalat, we cannot go and represent anyone. Same way, if probably one person is having a problem, okay, he has filed a suit. Can the neighbor go and say, no, I know, I am the neighbor, I know everything about him, so let me represent him? Can the neighbor say that? No, right? So it has to be a legal representative or a nominee, assignee, am I right? Somebody like that, power of attorney holder, agent. Only these people are known as authorized people and only they can represent. Clear? Pleader is included in that, of course. Then next one, section 120. Provisions not applicable to High Court in original civil jurisdiction. The following provisions shall not apply to the High Court in the exercise of its original civil jurisdiction, namely section 16, 17 and 20. You can just go through what are these sections once again. So section 16, 17 and 20, the High Court, the following provisions shall not apply to the High Court. Which are the sections? 16, 17 and 20. Just keep it in mind. Go back to section 16, 17 and 20 and write down the notes. Very, very important. That's why I'm telling you this, okay? Because when you're preparing for Judicial Services exam, try to be as thorough as possible, okay? So that writing the essay type answers, it will become very easy for you. That's why preparation of notes is very important. See, whatever, when you're reading, I'll just take 2 minutes off from the topic. Whatever you are studying, okay, just try to make a rough notes of whatever is there, whatever you have understood. Okay, if you have any doubt, you can just write it down there. Probably somewhere in the book you will get a answer for whatever question you are having. Am I right? So you be very particular, make the notes. Or if you are very good in remembering everything, then absolutely no problem. But one thing I would like to suggest, by heart is not of any use. Okay. Of course, section numbers and order numbers, all these things in all the subjects you have to by heart. But when it comes to analytical type of questions, whatever you have by hearted will give way. Okay. So then you will not be able to make much of the answer. Clear? So you should be very careful about that. Next we go to part 10, which speaks about rules. Section 121, effects of rules in the first schedule. The rules in the first schedule shall have effect as if enacted in the body of this code until annulled or altered in accordance with the provisions of this part. What are the rules that they are talking about? In CPC, all of us know there are orders and rules apart from sections. Am I right? So those rules which are there are to be read as a part of this code, CPC. Clear? So they are to be read as a part of this code unless it has been annulled. Annulled means what? Cancelled. Unless it has been cancelled or it has been altered, it has been changed. The status of the rules has changed or the status of the rules has been cancelled. Clear? Until then, you have to read the rules as a part of CPC. Section 122, power of certain high courts to make rules. High courts, of course, we know that each high court in every state has the right to make rules. Clear? Okay, high courts, not being the court of judicial commissioner, may from time to time, after previous publications, make rules regulating their own procedure and the procedure of civil court subject to the superintendence, and may by such rules annul, alter or add to all or any of the rules in the first schedule. So High Court has the power to annul, cancel, we already know this, alter any of the rules in this particular code. Clear? Then, of course, Judicial Commission doesn't have this power. You should remember. Then Section 123, Constitution of Rule Committees in certain states. A committee to be called as rule committee shall be constituted at the town, which is the usual place of sitting of each of the High Court. Why is it written? Because High Court is the one which has the power to amend or alter or annul any of the rules. Therefore, the Rules Committee also should be in the place where the High Court is. Clear? Then, each such committee shall consist of the following persons. Rules Committee means what? It is the committee which is formed under the aegis of the High Court to look at the rules, study, analyze, and to see whether it should be annulled or whether it should be altered. Clear? That is known as Rules Committee. That committee, the duty of the Rules Committee is this. Because High Court cannot sit in in analysis of all these things, because it has a lot of work, right? So Rules Committee is, of course, it consists of the same staff, but I'm just telling you that it is not it is not that the High Court passes it during the hearing of a case or something like that, okay? Okay. Each such committee shall consist of the following persons, namely 3 judges of the High Court, okay? You can just underline the words following persons. Namely, 3 judges of the High Courts established at the town at which such committee is constituted, one of whom at least has served as a district judge or a divisional judge for 3 years. Why is this compulsory? So that they will know how it is applied. See, basically, usually speaking, High Court is appellate court. It has original jurisdiction, but it is not always that we exercise the original jurisdiction of the High Court, right? Most of the times it is appellate or revisionary jurisdiction which is exercised, okay? So in that case, what happens? CPC is mainly followed. Practically speaking, CPC is mainly followed. I mean, if we have to file an IA also, right? Then in that case, we apply to CPC orders and rules. Am I right? This is how we do. So it is the civil courts, the district courts and the taluk level courts which actually do it on a day-to-day basis. Therefore, there should be 3 judges of the High Court established at the town, one of whom at least, underline the word at least, one of whom at least shall be a district judge. He should have served as a district judge or a divisional judge for 3 years. Okay. Then B, 2 legal practitioners enrolled in that court. Which court? In the in the High Court. Then number 3, a judge of a civil court subordinate to the High Court. A civil court, judge of a civil court subordinate to the High Court where the High Court is. Okay. Subsection 3, the members of each such committee shall be appointed by the High Court, who shall nominate one of their member to be president. So High Court, they will have 3 judges totally out of 1. At least one of them should be a district judge or should have been a district judge or a divisional judge. Right? In that also, the president shall be the one of the sitting judges of the High Court. It is not written whether it is sitting or retired judge. Clear? Then, subsection 4, each member of any such committee shall hold office for a period as prescribed by the High Court in this behalf. Why it should be prescribed by the High Courts? Usually when we see commissions or committees or anything, they have a fixed tenure of say 5 years, 2 years, 1 year, whatever it is. But here the tenure is fixed by High Court because this is purpose specific. It's not term specific, right? They are here to see whether the rules are in order and whether anything has to be cancelled or anything has to be altered. So, the time period of the committee also will be given by the High Court in this behalf, and whenever any member retires, resigns, dies or ceases to reside in the state in which the committee was constituted or becomes incapable of acting as a member of the committee, the said High Court shall appoint another person to be a member of this in his stead. Okay. So where a person becomes incapable either legally, either under law, or he does not, he ceases to reside. Okay. He shifts his house to some other place. Okay. Ceases to reside in the state where the committee was constituted, or he retires, he resigns, something like this, or there is a hitch legally for him to be a member of the committee. In that case, the High Court shall appoint somebody else in his place. Subsection 5, there shall be a secretary to each such committee. Secretary to each such committee. There, who shall be the president? One of the judges of the High Court. Clear? But who shall be the secretary? Who shall be who shall be appointed by the High Court and shall receive remuneration as may be provided in this behalf by the state government. Clear? So, who shall be the secretary? Anybody who is appointed by the High Court. Here it is not given that he should be a judge, he should be a lawyer, nothing like that. Okay? So, I think with this we will, we will do this next section also. Section 124, committee to report to High Court. Every rules committee shall make a report to the High Court. Why? Because High Court is the one which has to implement whatever are the directions given by the rules committee. So, and since High Court is the one which has appointed, which has established the rules committee and appointed the members, obviously report has to be given to the High Court. Every rule committee shall make a report to the High Court established at the town at which it is constituted on any proposal to annul, alter, add to the rules, in the first schedule or to make new rules, and before making any rules under section 122, the High Court shall take such report into consideration. So whatever is the report which has been framed by the rules committee, it has to be produced before the High Court, and upon production and further analysis, the High Court will think whether to annul a particular rule or alter it or add on to the rules. Some of the rules have been added, am I right? So that is also possible. Okay. Then section 125, power of High Courts to make rules. All the High Courts, see, as far as the state is concerned, High Court is the highest court. So even now, I mean, if you've been following the news either on Google or whatever, I mean, either by mobile or newspaper, if you're following the news, then you will know High Court says during pandemic, advocates will not enter the court premises, right? Clients will not enter the court premises. Sometimes only those advocates who are having the case, not sometimes, nowadays that is the norm, only those advocates who are having the case that particular day for evidence or whatever it is, only they are allowed inside, not others. So who makes all these rules? It is certainly not the state government. State government says lockdown is in place, you please see what to do. Then the High Court is the one which makes rules. Clear? Why? Because it is the highest court in the state. Then section 126, rules to be subject to approval. Rules made under the foregoing provision shall be subject to the previous approval of the government of the state. So whose approval? Just like how before any laws are promulgated, right? Then it has to be placed before the state government. Same way, I mean, the High Court and Supreme Court, there will be discussion surely. So it will be placed before the state government. Same way, when rules have been altered or annulled or added upon, it will be placed before the state government. Okay. A state government of the state in which the court whose procedure the rules regulate is situate, or if that court is not situate in any state, to the previous approval of the central government. So whatever is the report which is given by the rules committee, it shall be placed before the state government. Okay. But where there is no state government, then it shall directly be placed before the central government. Okay. We will stop with this. We will continue in the next class. Next class we have to start with section 128. Okay. Thank you.